What unfolded in the congressional hearing room yesterday left Supreme Court Justice Brett Kavanaugh visibly unsettled and sent ripples throughout America's legal circles. Representative Denzel Washington delivered a calm yet surgically precise constitutional argument that completely reshaped the trajectory of a judiciary oversight hearing in under 3 minutes. What was expected to be a standard procedural review instead became one of the most memorable constitutional confrontations in recent history. The turning point came when a visibly annoyed Kavanaugh chose to speak down. With all due respect, "Congressman," he began, his voice terse and dismissive, "these are complex constitutional issues that require deep legal expertise." Washington didn't blink. The room went silent not from volume, but from gravity. Everyone understood. A line had been crossed. What followed wasn't a rebuttal, it was a masterclass. A measured, thorough breakdown of First Amendment case law that left even the most experienced justice without a counternot from legal precedent. Not from doctrine, and certainly not from demeanor. If you're frustrated by watching accomplished black professionals being talked over or diminished despite decades of experience, what happened next wasn't just validating, it was pivotal. Hit that like button and subscribe, because what Denzel Washington delivered wasn't just a powerful statement, it highlighted deep consistencies in the court's constitutional logic that legal scholars will debate for years to come to fully grasp the weight of this exchange, why it struck such a chord, and why it carries lasting significance. You need to know who these two men are and what they stand for. Justice Brett Kavanaugh, 59, has served on the Supreme Court since his heated 2018 confirmation. A Yale graduate and former D.C. Circuit judge, he identifies as a textualist in the mold of the late Justice Scalia. He's firm on executive authority, strongly favors religious liberty, and has recently taken a bold stance in defending free speech. He often emphasizes the need for constitutional order and staying above partisan politics. Even as many of his rulings split along ideological lines. That brings us to the hearing itself. The session focused on how the court has handled recent First Amendment cases covering protest rights, campaign finance, and religious expression. It wasn't expected to generate headlines, but observers have long raised a concern that the court applies its so-called neutral principles inconsistently. Depending on the speaker and message involved, entered Denzel Washington. Now in his second term representing California's 43rd District, Washington didn't come to Capitol Hill chasing headlines. He came from the courtroom, a seasoned civil rights lawyer. He's taken on corrupt police unions, defended protesters in Ferguson, and argued voting rights cases in hostile jurisdictions. This isn't new terrain for him. And unlike most Judiciary Committee members, Washington doesn't rely on staff to brief him on legal precedent. He embodies it. What reporters and even the hearing attendees didn't know is that Representative Washington had spent the past 6 months leading a quiet but thorough review of the Supreme Court's First Amendment rulings over the last 5 terms, working with scholars from Yale, Stanford, and Howard. He helped assemble a careful but powerful analysis, evidence of selective constitutional reasoning no one had yet addressed head-on till now. The hearing was always going to get attention. It's rare for sitting justices to testify before Congress, but with public confidence in the court declining and ethical concerns growing, Kavanaugh and 2 other justices reluctantly agreed to appear after Chairman Jim Jordan guaranteed each member 5 minutes of questioning. What they didn't anticipate, what none of them could have foreseen, was that 5 minutes from one congressman would leave a historic mark. And Denzel Washington was just beginning. Few expected that when Washington leaned into the microphone, the next few minutes would turn into one of the most compelling constitutional moments in recent congressional history. The Judiciary Committee hearing room was packed shoulder to shoulder. An overflow room buzzed as viewers watched live streams on their phones and laptops. The atmosphere was formal and stiffened till it suddenly shifted. Justice Kavanaugh had just finished answering easy questions from senior committee members. He remained composed, his tone smooth and practiced. The chairman looked over his list and announced, "The gentleman from California, Mr. Washington, is recognized for 5 minutes." Kavanaugh adjusted slightly, ready for what he assumed would be a routine exchange. But Denzel Washington didn't do routine. He adjusted the silver cuff of his charcoal suit, precise and unhurried. The Constitution pin on his lapel caught the light, subtle but unmistakable. He flipped through a sleek black binder and placed it firmly on the table, then raised his eyes, focused, calm, and unwavering. "Thank you, Mr. Chairman," he began, his voice deep and deliberate. "Justice Kavanaugh, thank you for being here today." Kavanaugh nodded, expecting more of the same. "I'd like to focus on a theme you've emphasized in your written opinions: constitutional consistency. In your concurrence in Americans for Prosperity v. Bonta, you stated, and I quote, 'Consistency in constitutional interpretation is essential to the rule of law.' Is that still your position today?" Kavanaugh gave a nod. "Yes, Congressman. Applying constitutional principles consistently is central to the court's credibility and to upholding the rule of law." "I completely agree," Washington responded, a hint of something sharper beneath his calm tone. "Let's examine that together." He turned to the first tab in his binder. In Bonta, the case focused on disclosure rules for charitable donors. You joined an opinion stating that even an indirect burden on associational rights warranted strict scrutiny. Yet in McKesson v. Dew, a protest case, the court permitted a protest leader to potentially face liability for actions taken by others under a much looser standard. Can you explain what constitutional principle supports such different treatment of the same First Amendment right? Kavanaugh hesitated. "Those are very different contexts under the First Amendment," he began, trying to establish footing. "Donor privacy involves association rights in a distinct way compared to Washington leaned in slightly, not confrontational, just focused. The justice," he said, composed and firm, "both cases involve freedom of association. Bonta, the burden was confidential information shared with regulators. In McKesson, it was the risk of personal financial ruin for leading a protest where someone else committed property damage. Why does the first situation get strict scrutiny, while the second is left without that same protection?" The room fell silent. No rustling, no sidebar whispers, just attention centered on a Supreme Court justice now weighing his words carefully. "Well," Kavanaugh started, "the factual settings and the interests of the government involved?" "Yes," Washington nodded, "but the underlying principles, the constitutional standard, should remain consistent. Isn't that what the rule of law demands?" Kavanaugh paused. Washington didn't. He calmly turned another page. "Let's move to Kennedy v. Bremerton School District." He sided with the majority, finding that a public school coach had the right to pray openly on the 50-yard line. The court ruled that even potential indirect pressure on students wasn't enough to prohibit his expression. Washington raised an eyebrow. But in City of Austin v. Reagan National Advertising, just months earlier, you upheld limits on signage, literal expression based on vague concerns about aesthetics. In both cases, the court weighed expressive rights against speculative harms. Yet in one, speech was elevated. In the other, it was restricted. Kavanaugh shifted again, more noticeably this time. "Congressman, these constitutional questions are highly nuanced and context-specific." "I'm not oversimplifying them," Washington replied, voice low and deliberate. "I'm highlighting them because if the Constitution requires consistency, then selective application is what erodes that foundation. Trust and justice can't rest on standards that change based on who's interpreting them." He flipped to another tab. "Let's be even more specific. In Americans for Prosperity, you wrote that First Amendment analysis must be guided by history and tradition. But in Kennedy, the majority barely acknowledged long-standing traditions related to church-state separation in public education. Instead, the decision leaned heavily on modern interpretations of religious freedom. Tell me, Justice, how do you reconcile that? Same term, two cases, same constitutional clause. Two completely different uses of history and tradition." The room held its breath. The House Judiciary Chamber, already filled to capacity, had transitioned from passive attention to active focus. Reporters scrambled across keyboards. Phones adjusted slightly to capture clearer audio. This wasn't routine questioning, it was a methodical examination of constitutional integrity. Kavanaugh's unease became more evident. He adjusted a cufflink, leaned forward, then leaned back. "With all due respect, Congressman," he said, voice steady, but undeniably condescending, "these constitutional matters are complex and require deep legal understanding. Each case must be considered in light of its specific facts, texts, and precedents." And there it was, the misstep. Not just the words, but the tone, one that had underestimated the wrong person. Washington didn't raise his voice. He didn't react. That wasn't necessary. He held Kavanaugh's gaze and said, "Justice Kavanaugh, before I ever stepped into this chamber, I spent 15 years defending constitutional rights in courtrooms. I've argued First Amendment cases all the way to the Fifth Circuit. I've stood beside clients whose lives were overturned by government overreach. So when I speak about constitutional principles, I'm speaking from real-world experience." The silence returned. Even the camera seemed to hold still. He continued, steady and clear. "This isn't about differing facts. We all recognize that facts vary. This is about whether your legal reasoning shifts depending on who is speaking and what message they're delivering." He stepped toward a side screen and tapped it twice. 2 court opinions appeared side by side. "In these 2 rulings, it's both issued within the last 2 terms. Your court applied strict scrutiny to defend religious speech, but used only rational basis to review comparable secular speech. Yet the Constitution doesn't grant one form of expression more protection than another. You've written it yourself. The First Amendment guarantees freedom of speech, not a hierarchy of beliefs." Denzel stepped forward and opened a folder. Filled with writings from Madison and early Supreme Court opinions, the original understanding of the Constitution didn't play favorites. It didn't say religion deserved more protection than labor, or that corporations should have more speech rights than protesters. He turned once more, his tone steady but deliberate. "Dead. Here we are." Kavanaugh tried to respond. "Congressman, I assure you, the court aims for consistency." "But each case, Justice," Denzel interjected, not harshly, but firmly, like someone no longer willing to accept rehearsed answers. "I've reviewed 7 First Amendment cases from the past 3 terms. In every instance, the level of scrutiny wasn't guided by constitutional principle, but by political alignment. When conservative religious interests were involved, strict scrutiny. When it was about labor rights, progressive speech, or protest protections, suddenly rational basis was enough. That's not legal consistency. That's selective judgment." He displayed a clear, organized chart, case names, decisions, and levels of review. The pattern was undeniable. Even across party lines, committee members remained still. Some nodded in agreement, others stared at the chart like it had revealed a truth that had been easy to ignore. No one interrupted. "One more thing," Denzel added, his voice softer but more pointed. "Before your confirmation, your own writings cautioned against letting ideology guide interpretation. You said neutral principles must stay neutral. But that's not what we're seeing here." He took a step back. "You may call these issues complex, Justice. But when the same right is treated differently depending on who's speaking, that's not complexity. That's inconsistency, and it requires accountability." Silence followed. Denzel didn't posture, didn't seek applause, stood firm, letting the weight of the facts speak for themselves. In just under 5 minutes, he hadn't merely questioned a Supreme Court justice, he had exposed the inconsistency behind the rhetoric of neutrality, and he wasn't finished. The atmosphere in the room had shifted. This was no longer a routine oversight hearing. DenzelWashington.com and focused at the microphone had turned the session into something more meaningful. Not a performance, an examination. Justice Kavanaugh, once self-assured and somewhat dismissive, now appeared more reserved. This wasn't political theater, it was a grounded, factual challenge to judicial practice. Then Denzel opened his final binder steady, measured not for effect, but with the quiet precision of someone who knew exactly where the conversation was headed. "Justice Kavanaugh," he said, locking eyes across the table, "let's speak directly. I want to revisit your own words from your time before joining the bench." Kavanaugh blinked, clearly on guard. "You wrote in your 2012 Harvard Law Review article, and I quote, 'the cardinal sign of First Amendment Jurisprudence is treating similar speech differently based on the identity of the speaker or the popularity of the message. Ring a bell? Kavanaugh sat straighter. Yes, Congressman. I'm familiar with that article, good Denzel said without pause. Because I've reviewed all 23 First Amendment decisions issued since you joined the court, every single one. Let that point settle. And here's what I found. When the speaker was a religious institution, conservative advocacy group, or a corporate entity, you applied strict scrutiny every time. But when the speaker was a protester, labor group, or civil rights organization, you applied intermediate scrutiny, or less 91% of the time. The room was still, not just quiet, attentive. Denzel didn't need to raise his voice. He simply laid the facts down plainly and precisely. He clicked the remote. Two opinions appeared side by side on the screen. These two decisions, issued just 4 months apart, addressed nearly identical restrictions on speech. And yet he gestured toward the screen. Two completely different constitutional standards were used. The only meaningful difference? Who was speaking and what? They were saying. Kavanaugh adjusted his tie, visibly unsettled. Congressman, the court evaluates the particular facts in each case. The legal context matters. Facts may differ. Yes, Denzel replied with a nod. But constitutional principles should. Not. That's your standard. Justice, not mine. He clicked again. More excerpts appeared, this time from James Madison in early court opinions. Denzel wasn't just debating, he was guiding the room through legal doctrine with the confidence of someone who had spent years practicing it. You've built your judicial philosophy on neutrality, in interpreting constitutional texts through history and precedent. But the decisions I've reviewed reveal a different pattern. One where the intensity of scrutiny follows ideology more than the law. Kavanaugh tried again. Judicial rulings have to reflect real-world complexities. Constitutional interpretation isn't something you can reduce to a chart or a table. I'm not oversimplifying, Denzel responded, his voice steady, assured. I'm highlighting the inconsistencies, using your own words to do it. He leaned in slightly, the room holding still. The First Amendment doesn't weigh whether speech is comfortable or disruptive. It doesn't prioritize corporate religion over civic dissent. If we're going to uphold the Constitution, we must uphold it equally, or we're just selectively protecting rights behind judicial robes. Phones were raised not for sound bites, but for documentation. And here's the reality, Denzel continued, calm and deliberate. When the court changes its standards depending on the speaker, it's not interpreting the lit's managing perception. Justice Kavanaugh, visibly unsettled, pushed back. You're combining different strands of case law to create a misleading picture of bias. Denzel shook his head slow, composed. I'm not merging doctrines, Justice. I'm comparing. Your rulings side by side, the inconsistencies are visible on their own. He stepped forward, tone measured and precise. Take Americans for Prosperity. You said even minor burdens on association must pass strict scrutiny. But in Cedar Point Nursery v. Hasid decided in the same term, you joined an opinion applying only rational basis to a much more serious burden on labor organizing. That's also association, and also protected by the First Amendment. Without raising his voice, Denzel maintained a steady pace, each point clear and grounded. He turned to another document. Let's talk about history and tradition. In Kennedy, you joined an opinion that largely overlooked long-standing limits on religious expression by public school officials, yet in Bonta, you leaned heavily on historical practice. So which one is it, Justice? Does tradition guide your rulings? Does it depend on who's praying? The committee chair glanced at the clock and tapped his pen. An indication time was nearly up. Denzel noticed, gave a brief nod, then turned back to Kavanaugh with full focus. Justice Kavanaugh said, his voice calm but resolute. Respect the institution. I respect the position. What I'm asking is, what values does that robe protect and for whom? Because when this court applies strict scrutiny to favored speech and lowers the bar for speech, it disfavors the problem. Isn't just legal inconsistency, it's a threat to public trust. Kavanaugh stayed silent, not in poise, but in hesitation. "The biggest threat to First Amendment rights today," Denzel added, eyes steady, "isn't government censorship. It's the growing perception that legal protections depend on identity and message, not law or precedent, but public profile." That was it. No theatrics, no applause line. It's just a sharp conclusion grounded in principle. The murmurs followed slowly like a collective exhale. Committee members, including skeptics, nodded. Even some Republican colleagues who had arrived, ready to counter, were now quiet and not because they agreed with Denzel politically, but because what they had witnessed wasn't about politics. It was a pointed, fact-based critique. Kavanaugh sat motionless, hands clasped on the table, his expression unreadable. His usual confidence, shaped by years on the bench, seemed dimmed and settled by his own record presented plainly. A senior Republican member leaned toward a Democratic colleague and quietly remarked, "I don't share his politics, but that was a masterclass." Chairman Jordan, sensing the weight of the moment, cleared his throat. "The gentleman's time has expired. The witness may respond." Kavanaugh, gathering himself, answered, "The court works to apply constitutional principles consistently. What can appear as inconsistency often reflects the complexity of the issues and the facts specific to each case." Appreciate the congressman's thoughtful analysis. But his reply didn't address any of the direct examples raised. Not one. The justice, known for detailed reasoning and composure, had been met not with showmanship, but with structured, principled inquiry, and had no clear rebuttal. As the chair turned to the next speaker, a few members approached Denzel quietly. No cameras, no theatrics, just acknowledgement. A long-serving congressman, once a clerk on the D.C. Circuit, was overheard saying, "That's the most serious constitutional argument I've seen on this committee in 20 years, and came the public response. Within hours, clips of the exchange spread rapidly, not for their entertainment value, but for their substance. Hashtag constitutional class and hashtag Washington schools Kavanaugh were trending nationally. Over 30 million views in less than a day. Harvard law professor Lawrence Tribe tweeted, "In 5 decades of studying constitutional law, I've rarely seen a sitting justice so carefully and effectively challenged on his jurisprudence." Congressman. Washington exposed contradictions legal scholars have noted quietly for years. Even conservative voices acknowledged the moment. Former federal judge J. Michael Luttig posted, "While I agree with many of the court's recent First Amendment rulings, Congressman Washington has raised meaningful questions about consistency. His critique is serious and deserving of thoughtful engagement from the judiciary." By evening, major news outlets had shifted from simply covering the moment to analyzing the doctrine behind it. The story wasn't just about Denzel, it was about the issues he raised, the inconsistencies, the ideological leanings, and the growing credibility concerns surrounding the nation's highest court. And it all began with a calm voice that chose not to be ignored. By the next morning, the national conversation wasn't just reacting, it was rethinking. The New York Times ran a front-page article titled, "A Tale of Two Scrutinies: The Court's Divergent Approach to the First Amendment." The piece quoted extensively from Denzel Washington's exchange during the hearing, calling it a rare moment of constitutional clarity from Capitol Hill. Legal scholars across the ideological spectrum began reinforcing what Denzel had made undeniable. Not assumptions, but patterns, real, documented inconsistencies. That night, CNN hosted a panel of First Amendment scholars. Most weren't surprised by what Denzel had pointed out. They were surprised that it had finally been said directly and in public. It wasn't grandstanding. It wasn't politicking, said one conservative legal expert. He simply laid out contradictions we've long noticed in the case law, but no one had ever addressed them so plainly to a sitting justice. Within a week, law schools across the country requested permission to use the hearing footage in constitutional law classes. Georgetown Law announced a symposium titled "Scrutiny and Consistency in First Amendment Jurisprudence." Directly inspired by Denzel's remarks, the Yale Law Journal commissioned a special issue to examine the scrutiny disparities he had outlined on national television. Was official. This was no longer just a viral moment, it was shaping legal discourse. Meanwhile, inside the Supreme Court, the impact was felt. Justice Kavanaugh wasn't just the subject of political headlines. He was under scholarly review. Analysts noted how dismissive he had appeared early in the exchange, how he relied on titles and tone, only to be caught off guard by contradictions drawn from his own opinions. That afternoon, the Washington Post ran the headline, Kavanaugh's First Amendment record under review. Their analysis mirrored the one Denzel had delivered live. Inconsistencies in scrutiny based on the identity of the speaker, not the content of the law, across legal blogs and academic forums. A new idea began circulating, the Washington test. It wasn't a political jab or a PR term, it was a proposed standard. Does a justice apply the same level of constitutional scrutiny regardless of who is speaking or what is being said? One Harvard law professor noted, after 30 years of teaching constitutional law, this exchange has shifted how I talk about judicial impartiality. Even within the court, the discussion moved from private concern to open dialogue. The New Yorker reported that multiple justices privately acknowledged the validity of Denzel's critique, an exposure of long-standing tensions in the court's doctrine that had rarely been articulated so clearly, according to one anonymous source. Even a few conservative justices were uneasy, not just with the analysis, but with what the public might now perceive. If a member of Congress can trace these patterns so clearly, the source said, what does that mean for how objective we really appear? By then, the focus had moved beyond a single moment. This was about lasting impact. Denzel Washington's appearance at that hearing elevated his role in national discourse not as a celebrity or entertainer turned activist, but as a serious constitutional voice. Invitations poured in from universities asking him to lecture on the First Amendment and judicial consistency. The American Constitution Society invited him to keynote their national convention. The title of his address, Neutral Principles and the Myth of Equal Speech. The National Bar Association took it even further, announcing a new honor, the Denzel Washington Prize for Constitutional Integrity, awarded annually to a law student who demonstrates an exceptional ability to identify inconsistencies in constitutional reasoning. The first recipient, a third-year student from Howard University, called it a reminder that the law isn't just text-tied truth spoken by those willing to challenge power. Yet the most meaningful change wasn't the awards or coverage, it was in how Congress began approaching its constitutional oversight. Commentators coined a new phrase, the Washington medulla method of inquiry, driven not by party agendas, but by detailed, respectful legal analysis. No personal attacks, no theatrics. Just pointed questions based on doctrine and precedent. 2 weeks later, Pew Research released a national poll. 71% of Americans across the political spectrum said Supreme Court justices should be required to explain apparent inconsistencies in their constitutional interpretations. 64% supported enforceable standards on doctrinal transparency. The conversation had shifted, and people were paying attention. Then, 3 months after the hearing, the court returned to hear oral arguments in a major First Amendment case involving protest rights. The public tuned in not just to follow the lawyers or the outcome, but to see whether the court had taken note. Would the scrutiny remain consistent? Had the bench been influenced not by political pressure, but by a clear, well-reasoned challenge? Courtroom was full that day, yet what hung in the air wasn't just the present case, it was the echo of that congressional moment, that calm voice, a careful, reasoned critique. Denzel Washington didn't just pose a question, he became one. Do we still believe the Constitution protects everyone equally, or just those we already agree with? And America's answer was still unfolding. Court observers quickly noted a shift. In tone during oral arguments just weeks after the hearing, several justices, including Kavanaugh, began structuring their questions around the issue of consistent scrutiny, directly echoing the critique Denzel Washington had raised with measured clarity. Legal analysts took notice. Something had clearly resonated. 4 months later, when the court released its opinion in a new First Amendment case, all eyes turned to Kavanaugh's concurring opinion, and the shift was there. While he didn't mention Denzel by name, the message was unmistakable. The court must remain vigilant in applying consistent scrutiny standards, regardless of the speaker's identity or the popularity of their message. That principle is central to the integrity of the First Amendment. A Yale law professor writing for SCOTUS blog remarked, "This isn't the same Brett Kavanaugh we saw last year." His emphasis on viewpoint neutrality signals that thoughtful critique from a co-equal branch can indeed influence judicial development. 6 months after the hearing, Denzel introduced the Judicial Transparency and Consistency Act bill, requiring the Supreme Court to clearly state and justify the level of scrutiny applied in constitutional rulings. The surprise wasn't in the proposal itself, but in its reception, bipartisan support. Even traditionally conservative legal groups, often wary of congressional involvement in judicial affairs, endorsed it as a step towards safeguarding constitutional consistency and equal treatment under the law. The hearing was no longer just an event, it had become a pivotal moment. A moment when legal expertise outranked institutional hierarchy, when preparation challenged presumption, and when the voice of a black legal mind stood firm against being sidelined. Clips from the hearing spread under hashtags like hashtag How Denzel Demolishes Doctrine and hashtag First Amendment Masterclass. But this wasn't just viral content. It was educational. A widely shared TikTok from a first-year law student captured the essence. He didn't raise his voice. He didn't boast. He calmly broke down decades of selective rulings like basic math. That's real influence. 1 year later, the Georgetown Law Journal published a comprehensive review validating the inconsistencies Denzel had spotlighted during the hearing. That article became assigned reading at top law schools: Columbia, Stanford, Howard, and more. Entire constitutional law courses began their First Amendment sections with that very exchange. As for Justice Kavanaugh, he never acknowledged the impact publicly. But legal scholars began to take note of what they called the post-hearing pivot. His subsequent opinions began showing signs of more consistent application, less ideologically divided. One legal analyst wrote, "Kavanaugh's newer writings reflect a justice who now views consistency not as a choice, but as a necessity. What started as a challenge to uneven jurisprudence evolved into a foundational example of how accountability can reshape constitutional interpretation." Law schools now reference it not as a personal confrontation, but as a compelling instance of democratic dialogue where law, not volume, holds the power. Perhaps the most lasting impact appeared in a newly published constitutional law casebook. Its chapter on scrutiny levels began with a full-page transcript of Denzel Washington's questioning, paired with the reply that never fully addressed it. That chapter ended with a single line: "The strength of our Constitution lies not in avoiding critique, but in enduring it." If this story of legal clarity and principled challenge resonated with you, don't just scroll, like, share, and subscribe, because when knowledge is used to demand justice, and when calm, informed voices stand firm against pretense, the Constitution doesn't just exist, it thrives. Tell us what moments of speaking truth to power have stayed with you. Drop them in the comments. Let's keep this conversation going, because a republic that stops questioning loses the tools to protect itself. And real justice doesn't seek applause. It seeks accountability.